Please be seated. Veuillez vous asseoir.
Thank you very much. As part of the general agenda item, any other matter, the Chamber will deliver an oral decision the third of the day. This concerning the defense request for adjournment for 4 weeks. In its application filed on the 4th of September 2013, the Ruto defense made the following 3 requests. 1, leave to appeal the decision of the 3rd of September 2013. 2, an adjournment of 4 weeks following the opening statements, or alternatively, after the testimony of the first 2 witnesses, in consequence of the Chamber's grant of leave to the prosecution to add 2 new witnesses to the prosecution witness list, and 3, a shortening of the deadline for responses to that request. The request for shortening of deadlines for responses was overtaken by the Chamber's direction of the 5th of September 2013, requiring the responding parties to make their responses in today's status conference. Those responses were made earlier in today's proceedings. The Chamber will render in due course a written decision on the request for leave to appeal. As for the request for an adjournment of 4 weeks following the opening statement, or alternatively after the testimony of the first 2 witnesses, the Chamber now renders its ruling. Although this request is framed as a separate matter, the Chamber recalls that the defense had, on an earlier occasion, made a request of the Chamber that was, to all intents and purposes, similar. This was on the occasion of the defense response to the prosecutor's requests to add the 2 new witnesses to the prosecution witness list. As part of their response, the Ruto defense contingently requested the Chamber to adjourn the trial from the moment of disclosure of the statements of those witnesses, were the Chamber to grant the prosecution's request to add the 2 new witnesses. This, as the defense argued at the time, was in order to allow the defense time to carry out investigations. The Chamber considered and rejected that request for adjournment as part of its decision of the 3rd of September 2013. As such, this new request for a 4-week adjournment is, in effect, an attempt to relitigate a matter already litigated by the parties and ruled upon by the Chamber in its decision of the 3rd of September 2013. The Chamber has considered that the proceedings will leave a fair opportunity in the circumstances for the defense to carry out investigations into the credibility of the 2 new witnesses if the prosecution calls these witnesses towards the end of the prosecution case. Furthermore, the Chamber notes that the need to accommodate this trial and the companion trial of the Kenyatta case will result in sitting schedules that will entail adjournment in weeks, during which the defense should be able to continue its investigations. For instance, although the Chamber did not give a specific indication in its recent orders on the sitting schedule, the Chamber notes here that the sitting schedule for the trial period commencing on the 10th of September 2013, that is tomorrow, already contemplates 2 weeks of adjournment, namely the weeks of 7th to the 11th of October, and 4th to the 8th of November 2013. The Chamber further notes that other trial chambers of this court have similarly considered that any prejudice arising from the late addition of witnesses can be ameliorated by directing the prosecution to call the relevant witnesses towards the end of the prosecution case. That was the case, for example, in the 23rd October 2009 decision of Trial Chamber 2. Furthermore, pursuant to the Chamber's decision of the 3rd of September 2013 and the oral ruling of this morning, rejecting the prosecution application for variation of the time limit within which to disclose the identities of the two witnesses to the defense, the Ruto defense should by now have been notified of the ex parte version of the prosecution's filings in their application for leave to add those two new witnesses to their list. It should thus be clear to the Ruto defense that investigations into one of the new witnesses need not be as extensive as the Ruto defense had initially feared. And there's reason to believe that some submissions made by counsel during the private session, counsel for Ruto, during the private session, might have been an allusion to that fact. The fact of knowledge, prior knowledge of who that witness is. For the foregoing reasons, the Chamber rejects the Ruto defense primary request for an adjournment after the opening statement. As regards the alternative request to adjourn after the testimony of the first two witnesses, the defense has not provided any additional reasons for that alternative prayer. The prayer is also denied. It will be left to the prosecutor to make its own request for adjournment, if it so pleases, at a later time, in light of submissions we heard earlier. For the foregoing reasons, the Chamber rejects the Ruto defense request for an adjournment. That concludes the Chamber's oral decision on the matter. With that, we have 15 minutes to the obligatory cutoff time, in the sense that it will not be in our hands, but we must adjourn at 4, as the logistics of a courtroom require. Within that time, I will invite parties or counsel to indicate any other matter they may have.
With your leave, Mr. President, Your Honours. We're still quite confused regarding what is anticipated. And, Your Honour, I would appreciate greatly a degree of clarity from the bench, and perhaps ordered. As I understand it, we're going to continue with opening speeches tomorrow. And then we will adjourn until next Tuesday. I wonder if that is if that's the correct position. We'll adjourn until Tuesday, when a witness will turn up. Your Honour, if that's the case, I still don't have clarity regarding the witnesses that will follow. I know maybe the second witness and maybe even the third, but Your Honour, that's hardly a very auspicious start. I think we have a right in our respectful submission to have a little bit more clarity than that as to which are the next prospective prosecution witnesses, and of course then to have time to arrange ourselves so we can confront those witnesses and question them. Your Honour, I would invite the bench to order the prosecution to revise by the end of today, or at any other period deemed appropriate by the bench, its list of witnesses and so that the defence are standing on a surer footing regarding the weeks and months ahead, as far as not the court timetable is concerned, but which witnesses will be brought to fill that timetable. Your Honour, that's the first point. The second point is, and I'm not seeking reconsideration of the, yet again, of the decision regarding the two witnesses. But, Your Honours, I think a fair appraisal of this case shows that the bench has tried very sincerely to ensure that the rights of all parties, the victims, the prosecution and the defence, are balanced in a way that there's a fair trial. And I think that's been done. And various orders have been given to ensure that disclosure is given to the defence in proper time. One goes back to the 9th of January, and the order that all disclosure be given by then. But the reality is, Your Honour, we say that we are facing a position in which we are really severely prejudiced. Your Honour, I'm very happy, let me be very clear, and on behalf of William Ruto, to continue with trial based upon this witness list, these charges, and to confront, test this evidence, and put the case in Your Honour's hands to dispose of this case and do justice. But, Your Honour, that's not the landscape that we face. We don't have that luxury. We are facing really what I would describe as the unheralded situation, where the defence simply don't know what the landscape is. We're being asked not to hit a moving target, but in fact to hit an invisible one. And Your Honour, that's the only fair expression that I can put forward. Because here we are, trial tomorrow. The defence have done, I think, amazingly well to, whatever difficulties, to be ready to confront this case. Only due to no fault of our own, no fault of us, leave to appeal has been given on an absolutely critical issue regarding the temporal scope of the charges. I don't know when in the history of international justice a defence has been handicapped to such an extent where we're going to trial not knowing the time period that is relevant to the charges. But, Your Honour, that prejudice is compounded not only by the new witnesses, whose statements haven't even read as yet, the two witnesses, that's been disposed of, but also by the Regulation 55 matter that Your Honours have been briefed on for some time. Your Honour, this is not theoretical, and I do heed and the bench's decision that somehow the defence should anticipate all options. But, Your Honour, with the greatest of respect and trying with great sincerity to march on so that this case can be disposed of, we say that's not how it works. It's not for the defence to anticipate every single option. It's for the party opposite. It's for the prosecution to state their case with clarity. And, Your Honour, that's exactly why we have a confirmation. Otherwise, the pre-trial chamber, really, we can save costs and dispense with it. Money can be used elsewhere quite efficiently. But, Your Honour, those that drafted the statute, for right or wrong, we have a pre-trial chamber. And if that has merit, it's to serve as a purpose to fix the target. Now, Your Honour, here we are, this triple whammy or quadruple whammy of prosecution investigations, not exceptional, not as an exceptional one-off, but routinely massive investigations after the confirmation case that prejudiced the defence. Defence are being run ragged by late disclosure, run ragged by new allegations, and to be faced the day before with new witness statements, an unknown temporal scope of the indictment, and the regulation, the uncertainty regarding the legal characterization, is, we say, individually, but also cumulatively, of such prejudice that the trial chamber, we would invite the trial chamber to consider whether or not it is right to proceed with the hearing of evidence. Your Honour, one of the reasons why we want to have the trial commence is, Your Honour, we're all waiting for it. Our client, William Ruto, has had nonsensical, unfair, erroneous and deceitful allegations raised against him for some time. And so, Your Honour, we don't want to delay that. We don't want anybody to say that we're running scared or that somehow we're seeking to evade justice. He will be here tomorrow. He will present himself voluntarily once again. In fact, he's here today. But, Your Honour, we do say that prejudice is there. And, Your Honour, what I would ask the court to consider,
Mr. Khan,
with the last point, Your Honour, with your leave, just one paragraph.
very, very
Your Honour, it's the
quickly and
appeals
to the
chamber.
point, so
I'm
that
grateful.
your
Your Honour,
colleagues
it's
can
the appeals
also...
chamber decision in Muvunye, the appeals chamber of the ICTR, 29th of August 2008, ICTR 2000-55A-A, paragraphs 29 to 30. And really, in our respectful submission, this paragraph shows the double jeopardy that the defence is facing. And Your Honour, let me read the relevant aspect. The appeals chamber noted the trial chamber decision, and I quote, that the accused would have expended time and resources preparing his defence on the basis of the indictment filed. That was the reason why amendment was denied. The appeals chamber continued, moreover, the trial chamber added, quote, that to amend the indictment on the eve of trial and in doing so introduce new material elements, as the prosecutor seems likely to do, is likely to cause substantial prejudice to the rights to prepare his defence. That's one aspect.
Mr. Khan, I must cut you short. No doubt you'll be making that submission to the appeals chamber in your pending appeal that's coming up, I take it.
No, Your Honour, this is different. We're not raising before the appeals chamber these panoply of issues, because, Your Honour, these issues are the cumulative prejudice caused by not only the Regulation 55, the temporal, the uncertainty regarding the temporal scope of the indictment and the new witnesses. There's no forum for us to plead prejudice and unfairness except the bench that we have the honour of appearing for today. And Your Honour, it's not much more, because that's the first aspect of the appeals chamber. The second, they said significantly, after finding prejudice to the defence, significantly in relation to the proposed amendment to broaden the date range with respect to the attack on the hospital, and it goes on, the trial chamber held that the expanded date range alone, might necessitate further investigations. The same rationale, this is the third point, the Regulation 55, the same rationale applies with even greater force to changing the mode of Muvenya's participation in the attack.
Okay, 1 second. We have 5 minutes left, and
Your Honour, with
10 minutes over 15. It would be fair to have the other side a chance to respond before we adjourn, because at 4 we have no option. It's not in our hands. At 4 o'clock we have to stop because of the tapes.
Your Honour, I'll sit down. I would invite the bench, after I sit, to also look at paragraph 30 of that decision.
Thank you.
Which is also really pertinent. But, Your Honour, as we say in the circumstances, let's start with the trial. I have no problem with dealing with the next 2 witnesses, but, Your Honours, an adjournment is needed in this case, so the defence have fixed contours of what is the allegation that it has to face, and if we don't have that clarity that we're entitled to, we say that this process is imperilled.
Thank you.
Thank you, Your Honours. I'm not entirely sure to what I'm expected to reply, because I didn't hear any relief that was being prayed for. My understanding is my learned friend is prepared to start with the trial tomorrow, but in due course he may apply for an adjournment. In due course I will respond. But the prosecution is in agreement that we should start the trial tomorrow, and my learned friend has now pertinently addressed the issue of the pending appeal. He's not relied on that to seek an adjournment, and I presume that that is his final word on the issue, and that's all I have to say. Thank you, Your Honours.
Your Honour, perhaps I can clarify. My learned friend made it very clear in his own submissions that there's an issue, for example, in relation to, I think it's the 6th, 7th and 8th witness. And in fact, he said in court today that his view on that in part would be informed by our approach to the leave to appeal that's been granted by the single judge. Your Honour, the relief that's been requested is open the case, start the case and adjourn until we know what are the parameters of responsibility that we have to answer It is not for the defence, with the greatest of respect, to anticipate all different variables of criminal responsibility. It's for the prosecutor, in discharge of her responsibilities, to investigate and put an application forward. And thereafter, it's for the pre-trial chamber to establish what is the mode of liability. That's been done. And changing the rules of the game on the eve of trial is massively, we say, prejudicial. And that's why, Your Honour, as I did say, it would imperil the process. But the application is to adjourn after opening or after the second witness to allow the defence to have certainty. Hopefully the appeals chamber will not take too long to decide the issue of the leave to appeal on the temporal scope of the indictment. Your Honours have already indicated that by, I think maybe the 20th or thereabouts of September, before the end of the month, we'll get a decision regarding the Regulation 55. In assessing the balance of convenience and the balance of fairness, we say that it militates in favour of granting the adjournment, so we get clarity on those two critical issues, the legal characterisation and also the temporal scope of the charges, before we get too far involved in this case. To do otherwise is to ask the defence to fight a phantom.
It looks like we're out of time now. Court officer, is that the case? Right, the court officer indicates that we can proceed for another 10 minutes, and I see nodding from the interpreter's booth and also from the court reporter's booth. Mr. Steinbergen, I understand you have...
Thank you. I'm grateful, Your Honours. I omitted to respond to my learned friend's second request, and that was to give an indication on the order of witnesses. Now, the prosecution intends to continue with the fourth witness and to, as far as possible, follow the list of witnesses as set out in the order which it has given earlier. I've already highlighted problems with witness number 10, who it may, at this stage, seems will fall out, and certain witnesses further down the line. But unless the defence object to hearing any particular witness on the basis of the pending appeal, that is the order we intend to follow. I cannot predict what may happen down the line. If I get a call tomorrow and say the witnesses 7, 8, and 9 have withdrawn, obviously that's beyond my control and we will have to adjust accordingly. But that is, as presently advised, the prosecution's intention. I hope that clarifies that matter. Anything else?
Mr. Kigen-Katwa, do you have any... You shake your head.
Your Honour, I do not wish to say anything.
Nothing. Thank you.
Thank you.
Mr. Director?
I have nothing, Mr. President.
And that brings today's proceedings to an end. We will see everyone here tomorrow for the commencement of the trial. Good luck.
All rise, veuillez vous lever.